Okay, we're going on the record on cause number DC 189386, Grimp versus Wilson. Counsel, make your appearances.
Rhonda Holcomb with the Lacrone Law Firm for defendant Carolyn Millage.
All right, and Mr. Myers is not here. I don't. Did you say he didn't file a response either? Is that correct?
Not that I've seen.
Okay, go ahead and proceed, Ms. Holcomb.
Yes, Your Honor, I will keep this as brief as possible. The cause of action accrued on July 18th of 2016. Plaintiff filed his initial petition 2 years to the day on July 18th of 2018. That initial petition did not name Carolyn Millage. 1 year and 8 months after the statute of limitations expired, plaintiff amended the petition to add Miss Millage, with facts varying as to her involvement in this accident. Again, it's pretty straightforward. He didn't meet the statute of limitations, so this MSJ is based on statute of limitations, and that affirmative defense, and that the cause of action against Miss Millage should be dismissed. Like I said, Mr. Myers, that I have seen did not file a response to this MSJ, but
did he file a non-suit of it?
Now that non-suit was as to Miss Karen Wilson.
A different party.
Yeah.
Okay.
So shortly after we filed this MSJ, statute of limitations MSJ as to Miss Millage, there was an amended petition filed, and that petition had a section about equitable tolling, and that because the deception of the driver of the vehicle, statute of limitations should be deferred until plaintiff knew, or by exercising reasonable diligence, should know of the facts giving rise to the claim. There has been no evidence presented that my client, Miss Millage, was involved in the accident, or that there was any deception on her part. Nor has there been evidence presented that there was deception on the part of anyone that is actual evidence in record. Plaintiff has non-suited Miss Karen Wilson, who plaintiff alleged was either the driver or the passenger and may have had another insurance policy. That person has not even been deposed, and he non-suited her. At the time of Miss Millage's recent deposition, the plaintiff, Miss Grimp, was present with her counsel. And after Mr. Myers completed his questioning of my client, I asked him if he would allow me or allow his client to go on record so I can ask her one question, whether or not she saw my client at the scene of the accident. Because of course, when the plaintiff was deposed before, my client was not even, Miss Millage was not even named to suit. He refused at the time to allow her to answer that one question, to dispose of whether or not Miss Millage was even present at the scene of the accident. Certainly there has been some statements made by the plaintiff early on after the accident to the insurer that leads a reasonable assumption that my client does not fit the physical description to place her at the scene. While Mr. Myers did vaguely mention something about possibly offering an affidavit of sorts, he has since been unresponsive to date.
Did you already submit an order for this?
I believe I did, Your Honor.
When did you submit that?
I believe we filed it with the motion, and I will just double check that.
What day did you file the motion?
On October 1st of 2020.
Let me see.
And it looks like we did file an order as well.
Okay. I just printed out another order. If you could bring it to me on a different order, but I need to sign that one as well. Okay, I'll sign the order of non-suit as well as the summary judgment as the other defendant. So anything else today, Ms. Holcomb?
No, sir. Thank you, Your Honor, for your time.
You have a good day. Be safe out there.
Thanks. Bye-bye.
All right. everyone here? It's not quite 4 o'clock on the Hume case. Everyone here on that?
It looks like it, Your Honor.
Your Honor, we're waiting for one other attorney from our office, but I think he's logging on.
Okay. Everybody have a good Thanksgiving this week or last week?
Yes, Your Honor. How about you?
It was good. It was good. I missed my dad. I hadn't seen him for it's the first time in 20 years I didn't see him for Thanksgiving, but we got to Zoom. It was not quite the same, but we got to Zoom with him. That was it. So what about you guys?
It was good.
Ms. Shigaris, how was your Thanksgiving?
It was good, much quieter. Just my dad and my husband and I. So last year, I think we had like 20 people at our house and about double that in dishes. So it was quite an adjustment, but it was nice that the weather was good. My dad came over and we sat outside. So
It's getting kind of cold out there.
yeah, I don't think we could do that now.
No. All right. I think your other attorney's here, Mr. Ortiago.
Okay, great.
Go ahead and get this started on, we're still on Zoom. So let's go on the record on cause number DC 208643. Counsel, make your appearance.
Julie Pettit and David Urtiago on behalf of the plaintiffs.
Leslie Shigaris and Jessica Lopez on behalf of the FSG defendants.
Good afternoon, Your Honor. Ben Reamer here on behalf of Michael Nall and Mid-Marketplace PBC LLC.
Good afternoon. This is Sarah Krajewski on behalf of Defendant Southfield.
Is that everyone? Okay, let's go ahead and proceed.
Thank you, Your Honor. Maybe I could start with just giving you an update of where we are from our last hearing. If you recall, Your Honor, the discussion was that we would produce the relevant documents to the plaintiffs in this case over the last 2 weeks, which we have done so. I can get into detail, but just on a general level, Your Honor, as far as financial information, what has been provided to all counsel in this case includes monthly financial packages that include balance sheets, income statements, financial statements, since our clients took over the assets of the company of May 2018 to the present, weekly cash flow statements that show all of the cash in and out of the company, even down to the vendor level. Those reports have been produced. Those kinds of weekly cash flow statements only started being generated late last year. So we produced those all the way to the present, some QuickBook files, and those types of documents. After the last hearing, because I wanted to make sure that there was no dispute as to the scope of what Ms. Pettit was seeking and needing, we conferred, and she was gracious enough to send me an email last Monday itemizing out her request, so that way we could double check that. We've looked through the list of items that she requested, and everything that she has requested we have provided to her, other than there's one request where there wasn't anything particularly responsive. That included us generating reports that the company doesn't normally keep, so that way we could provide this information to the plaintiffs. In addition to the financial information, I think you'll recall just a few weeks ago, our responses to plaintiff's discovery were due. We had not yet produced the responsive documents. Based on my communications with Ms. Pettit, she understood that part of the order from Your Honor was to produce all of those responsive documents. So we've done that as well, with one exception. I've been keeping Ms. Pettit up to date on certain email custodians where we had to review manually to make sure that there weren't any privileged documents that were being produced. That the majority of emails that were responsive got produced last week. The last batch, the production review, finished today, and that's being processed for production as we speak. And that will complete the defendant's production, not just of the financial information, but all of the documents that are responsive to plaintiff's request for production in this case.
Okay. So we're all good. Is that right, Ms. Pettit?
If only it were that easy, Your Honor. Ms. Shigaris and her firm, I think most of the documents came in on Wednesday of last week. I believe there's around 37,000 pages. I did send Ms. Shigaris an email indicating that the items that we were most interested in, she was not able to identify the Bates numbers where we could find those documents that we're actually interested in. So we had 3 lawyers over the holiday weekend spend the entire holiday weekend going through the 37,000 pages. We're not all the way through them, but the vast majority of the documents that we have come across so far that are financial documents are documents that our client produced to the defendants before the equity transaction took place. So I'm not saying that the documents we've requested are not within the 37,000. What I'm saying is we haven't been able to locate them within the 37,000 documents so far, and Ms. Shigaris was unable to identify the Bates numbers for where we could find those particular documents. Additionally, I do believe there's at least one QuickBooks file that has been produced. I informed opposing counsel that we're unable to open that file and need specifics on what type of QuickBooks software would be necessary, because typical QuickBooks is not opening that software. So I'm still waiting on instructions on how we can access the data within that file. So based on that, I essentially we find ourselves in the same position where we were previously, which is we don't have, again, I'm not saying that it's not in there. I'm saying that so far we've not been able to locate the list of items that we are seeking. For that reason, we would ask the court to continue with where we were prior to the last hearing, which is a request for a counter supersedious bond to be set so that Mr. Buchanan can just go in, request the documents that he needs, and get access to them to report back to the court.
Your Honor, if I can just address the issues that were raised by Ms. Pettit, because hopefully I can short circuit this. First off, Ms. Pettit did ask for Bates labels that we could identify on Wednesday. Like Ms. Pettit's firm, we had lawyers working through the holiday weekend to complete our production. And so what I told her was we could try to get that information to her this week, but because the entire team was working on making sure we complied with what I promised the court we would do, which was get all the production out before this hearing, I didn't have someone that could go off and look at the documents, because that's not how we had them sorted. We knew what documents were there. They go off to a vendor, they get Bates labeled. So I was going to need to have someone on our end manually go through the 40,000 pages, not documents, but pages of documents in order to, on our end, compile that information to get to Ms. Pettit, which I told her I would do this week. I just couldn't do it on Wednesday because we were trying to get all the production out. So that's something that can be provided, and we are already in the process of working on that information. The second thing, and I'm assuming Ms. Pettit just missed it, but she did ask for some information about how to open the QuickBook files. My colleague, Ms. Lopez, sent a very detailed multi-paragraph email that walked through exactly what to do and what information to use. So I'm happy to resend that as soon as we get off the hearing, but I saw that email go out last week, I think on Tuesday or Wednesday. So I'm assuming maybe that Ms. Pettit just missed it.
Yeah, I may have. If that's the case, if you'll resend it to me, that would be great.
I'm happy to do that. So I don't understand the point, I guess, of under your prior order, Your Honor. It was so that Mr. Buchanan could go in and I look at the financial information and provide that information to plaintiffs as well as Your Honor, so Your Honor could make a determination if a broader receiver was necessary. Based on our last discussion, instead of having the company have the expense of a receiver come through and gather this information, we produced it all. So now plaintiffs have access to it. I understand that not only given the time period, but the holiday weekend, they haven't had time to review all of that information, but they have it and they have access to it. And the lawyers and their experts can review it. And if there's something that they have questions about, that can be handled through discovery.
I feel bad that anybody's holidays were ruined. That was not the court's intention at all. I'm wondering if it makes sense to maybe move this hearing a week or two, just to give Ms. Pettit's office an opportunity to kind of look through the documents, or client a chance to look through the documents. And did Ms. Shigaris, I wasn't clear, did you say that you still needed to Bates stamp some of these, or they were finally Bates stamped?
The only thing that is in the process are a subset of emails that are responsive to the discovery request, not the financial documents. That email subset is in the process of being produced or Bates labeled right now. So they have all the financial documents. Those were produced in 3 different batches last week. But the email production, the last piece of it still needs to get Bates labeled and get generated to them.
Your Honor, if I may, again, I'm not saying that these documents aren't in there. What I'm saying is the majority of the ones that we've come across is simply data that's, you know, like we had people all weekend going through data from 2013 and 2014 that my client produced to the defendants years ago and before, or during the due diligence period of the equity transaction. So one just simple example is my client for a year and a half now has been asking for all of the data and the detail for the 2019 5-star conference. That's kind of what started this entire thing. That may be in there, but somewhere within the 37,000 pages, we haven't come across it yet. And I think those are the types. Let me say one other thing. The limited 2020 data that we have been able to mine from this voluminous production does show what my client had feared, which is that the company is definitely not in good financial condition at all. So the limited data that we have seen makes us think that the company is in dire financial condition and Mr. Buchanan's help is needed. And the simple things we've asked, like for a year and a half on the 2019 data, I still, as of right now, haven't seen, even though it may be somewhere in this production. So again, we would ask that we not delay any longer and that Mr. Buchanan have the authority to simply go in and say, hey, we want to see the 2019 5-star data and have quick and easy access to it so that we can move everything along.
And I guess what's the point of, we have spent so much money and time, Your Honor, generating this information, including what Ms. Pettit just asked for, which was not information that was readily available. We had to generate reports to get it in a format that was usable. As I mentioned to Ms. Pettit last week and reiterated to Your Honor, I'm happy to point her in the direction. The reason that Ms. Pettit has seen documents that were produced by her client was they sent a request for production for us to produce everything that was in the due diligence room before the FSG transaction closed. When I asked Ms. Pettit about the scope of the production over the last 2 weeks, her exact words were to me, I thought you were producing everything that was responsive, not just the financial documents. So I responded to her and I said, okay, then that's what we'll do. So I produced everything. And now I feel like we're, you know, it's kind of a catch-22. If we were going to have Mr. Buchanan come in anyways, then what was the point of spending the time to get her the documents? And so
Ms. Shigaris, I kind of agree with you. That does seem, you know, that's why I'm thinking a week or two to give Ms. Pettit an opportunity to go through or her office an opportunity to finish going through the documents. It sounds like we're kind of mid-review. And if Ms. Pettit, there's specific documents you don't think are there, I would like you to give Ms. Shigaris' office an opportunity to say, look, this is the Bates numbers, where they are, or something like that.
Yeah, I don't think that's unreasonable at all. I guess, you know, to Ms. Shigaris' point, this has been an extremely expensive exercise for both sides. And so if these documents are hidden within there, that's fine. I think that, you know, if they can really this week identify by Bates numbers the ones that we're after, that's going to save everyone a lot of time and money. So if it's something that can happen this week, like I said, we've worked through the weekend, 3 lawyers have on doing this, and I think we're about 15 or 20% of the way through. So there is a lot still to sift through. But if they can identify those by Bates numbers, then that might, you know, shortcut.
Have you told her exactly what you're really looking for?
Yes, Your Honor.
Yeah, and that's something we can make sure that, like I said, she sent an email last Monday. And so we've already started that process of identifying the documents in particular of interest for her by Bates level, as well as just kind of wholesale, like here are the categories. These categories of documents are in this Bates range and so on and so forth. And I suspect without any issue, we would be able to get that to her by the end of the week, if not sooner, you know, because it's already underway, Your Honor.
Yeah, something like that would be extremely helpful. So if the idea is maybe to push this a little bit further, I hate to continue to push things, but it sounds like that might be an efficient way to cut to the chase on the documents that we're seeking.
Okay, well, do you want me to reset this for a week or 2 weeks? What do you think would be reasonable? I don't really care, whatever's easiest for you guys.
I would probably suggest 2 weeks just to make sure Ms. Shigaris' firm has time to identify everything, and then we can go back and look at it.
Okay, let me just make sure that Mr. Buchanan will be available on, is it December 13th?
I think that's a Sunday.
Is it? Oh, I'm looking at the wrong year, sorry. December 14th, yes, you're right. December 14th, Mr. Buchanan, will you be in town?
Judge, this is Cassie. I think Kevin just had to take a phone call, but yes, I think we will be able, assuming it's a Zoom hearing, we should be available.
Ms. Pettit, will you be back from your honeymoon?
I will. I have a full day mediation that day, so if we could either do this hearing early or late that day, that would be.
What time is your mediation?
It doesn't start till 9:30. The mediation.
When do you get back? I guess the one other issue I have is I know that you, because of the other trial we have, that we had to move because of your honeymoon. Do you have when are you gone on your honeymoon?
I'll be back on the 13th, Your Honor. That Sunday.
Will you have time? Will your office have time to kind of go through all this?
Okay.
I just don't want to keep setting this and get everyone together if we're not going to be ready.
We will be ready on if Ms. Shigaris can get everything to us this week, then we'll have it done. We'll have time to double check and review all the dates numbers before then. If we want to push it one more week, that might be the safest thing, but I can make the 14th work.
I can make either work, Your Honor, and we will get that information to her. Can I raise one other just logistic issue as we're talking about the hearing?
Sure.
One of the things that I think put the court in a difficult position at the last evidentiary hearing was we submitted everything by way of affidavit initially. And I think that left the court faced with the lawyers trying to explain the different financial information in kind of a vacuum. And I don't think that was as helpful. And so my request would be if we're going to, and I guess it depends on what Ms. Pettit determines, but based on her comments today, I suspect that whatever she reviews, when we come back, she's going to be saying, well, we need a receiver because of the financial condition of the company. And so we will want to put our current CFO, who has the working knowledge of this information, as well as potentially one of our other clients who can kind of explain Your Honor, the finances that you're looking at, as opposed to having me try to make sense of it all. So I don't know what kind of time frame or timing, but if we're going down that path, that's what we would request.
If I may address that, my thinking or understanding was that rather than go through that exercise of explaining to the court the financial condition of the company, that's where Mr. Buchanan and his team and their expertise would come in, which would be to get the documents, review it, and then make a potential recommendation to the court, so that the court wasn't, hearing from all of the CFOs and all of that. I think part of Your Honor's order was that Mr. Buchanan was going to interview people like the CFO, as well as the former CEO and all of the players, so that he could make that type of determination and then subsequent recommendation to Your Honor.
I mean, the goal of this whole process right now has been to try to avoid having a receiver altogether, I think, right?
That was my understanding, Your Honor. So I just want to, we're happy to proceed however you want, but I want to make sure that the court has ample information at its disposal to make the best decision, which I know is what the court is interested in doing.
I mean, I kind of feel like if they produce all the documents, I mean, that's why we're going through this, then we would need to have no receivership, or we'd have to have a full receivership. If you determine that the company, if not you determine, if I determine that the company is, needs a receiver to run it because of mismanagement or whatever, then, but we're going through the process right now of providing all those documents, and that was kind of going to be Mr. Buchanan's role. I don't know. I mean, Um,
I'm happy to wait and see after Ms. Pettit has reviewed the information, the direction she's headed. But like I said, some of that will determine what type of testimony or evidence we feel like is necessary either at the next hearing or next proceeding as the court deems appropriate.
my concern is just that, or not my concern, my guess is that that you guys are not going to agree when we get through all the documents is my fear. And then I'm going to have to make an assessment of whether or not this company should be put into a receivership on a very hotly disputed, basis. And I'm concerned that that's kind of why I wanted to have Mr. Buchanan take a deep dive, because I just don't have the bandwidth to do that. I don't have that's what Mr. Buchanan's role was, to be an objective observer into that. But I guess we can, I don't know, Mr. Buchanan, are you there?
I am, sir.
Do you have any thoughts about all this?
I think that additional time for Ms. Pettit to review the documents is a good idea. There is a difference between reviewing documents and having the ability to interview a CFO. There is a difference.
The purpose of appointing you was for you to do the deep dive, to take the look, talk it to everyone, interview everybody. And I'm worried that this whole process that we're going through right now, my hope was that Ms. Pettit would get the documents, she would be happy, her client would be satisfied, that there would be some way to reach an agreement. I'm beginning to feel that may have been a mistake. Would it be more efficient just to, I don't know, to appoint you now and just have you look through everything? I don't have time to go through 40,000 documents and interview half a dozen people. That's not, it's not something that I would have time to do. What do you think?
Judge, again, I'll be careful not to advocate. Just the observation is there's a big difference between kicking documents back and forth and sending emails back and forth about where is this document, where's that document, as compared to or contrasted with the ability to pick up the phone, call a CFO and go, hey, I need to see this. Where is it? I need to see it now. That's the difference here with the receiver. Again, I'm sure Mr. Garris thinks I'm advocating, but I think I'm giving you an example, or giving an example of what the court's observation or concern is.
Well, and respectfully, Your Honor, the problem is there has to be a threshold finding that a party is entitled to the receivership. And I understood your concern at the last hearing was that you weren't in a position to make that determination. You did not have a good understanding of the financial condition of the company, that there was information being explained by the lawyers that did not give the court enough information to make a determination of A, what the financial situation of the company was, and B, whether there had been fraud or gross mismanagement, which has to be a predicate finding in order to put this company into receivership, whether on a narrow basis or a broader basis. So I understand Mr. Buchanan's practical consideration of, and the court's concern, of course, that you don't have time to dig through these documents. But that's why I'm requesting that maybe the lawyers made a misstep when we were trying to help accommodate different scheduling conflicts and provided the information initially by way of affidavit. And so if we have the next hearing, which I agree with you, I think it sounds like from the comments today that no matter what is reviewed, we're going to be back here and the plaintiffs are going to be asking for a receiver. And so if that's the case, then we would request that the defendants be able to present testimony to establish the record that shows that they have not met their basis to obtain a pre-trial before the merits receivership in this case.
Your Honor, if I may respond to that briefly, Your Honor already signed an order and found that there was sufficient basis for the limited receiver. So that's been signed. That order has been entered. It's been, that's of course when the competing bonds were filed. And now we're moving for the counter supersedious bond, but that order has been entered.
Yeah, I guess, Mr. Garris, I don't know what the hope was that this would be a way to avoid the receivership, but I have appointed the receiver already. I don't really want to go back through and do this all over again. You know what I mean? I don't want to. I've already made those findings. I've already said, maybe I'm wrong, maybe I'm right. I don't know. I feel that we took a close look at this, and I think that there's a basis for receivership.
I'm sorry, I thought you were talking about the broader receiver. I thought that we were discussing the point was to gather the information.
That's a very good point. I think that if I decide to expand the receivership, then I probably would want to have live testimony. Does that address your concern?
Yes.
Okay.
And so then I guess then that leaves us with, under the current order, and I understand obviously we have the issue of the different bonds that needs to be addressed by the court in some fashion, but whether or not Ms. Pettit benefits from actually reviewing all of the work that we've done over the last 2 weeks to get her the information that she claimed she didn't have access to and needed to have access to before we do anything else. Otherwise, I'm not sure what the point of all that work was.
I mean, isn't it documents the receiver would need anyway?
If it please the court, Your Honor.
Yes.
I don't view any of the work that Ms. Chigueras and Ms. Pettit have done the last 2 weeks as a waste of time. It fits largely, or would have fit largely into what I would have anticipated asking to be provided to me. Perhaps not in the same format, but at least in terms of the research and digging, so to speak, and mining of those documents. So I don't view any of that as being a waste of time. And to the extent that I'm the receiver going forward, whether limited or full, it's just not a waste of time for Ms. Chigueras and Ms. Pettit to really have a great or good understanding of what the company's financial documents look like. It's not wasted time. It's not wasted money, because I can pick up the phone or shoot an email, typically would copy both of them going, hey, point me in the right direction. And so, because that work's already been done, we don't have to replow the same ground. That's my observation.
Okay, so let's move on to what we're hearing today, which is the emergency motion for counter supersedious bond. Is that it?
Yes, Your Honor.
Okay, we don't have a lot of time for this, so let's get to it.
Okay, with Your Honor's permission, Mr. Urtiago is going to argue the bond portion.
Okay, quickly.
Thank you, Your Honor.
Your Honor, I think that to be as quick as possible, the declaration filed by Mr. Buchanan indicates that his budget or his anticipated cost for his limited receivership is $21,875. We think that is the outer limits of accounting for this in this instance, simply because that's the most amount of money that there's any evidence that the company would incur if Your Honor would allow for the receivership to go into place pending an appeal. Of course, our initial argument, Your Honor, is that we've already posted a $10,000 bond, and that $10,000 bond was calculated to secure against the losses that the counter supersedious bond is calculated to secure against. So essentially, we've already paid the bond that this counter supersedious.
Mr. Urtiago, didn't when I set the $10,000 bond, that was before Mr. Buchanan filed the estimate on the cost of the receivership, correct?
That's correct.
All right. Response, Ms. Chigueras?
Yes, Your Honor. First off, there are two separate bonds. There's a bond that gets posted under the rules related to the appointment of a receivership. Second, if the court is going to preclude our ability to supersede, which we are allowed to do under the rules of appellate procedure, another separate bond needs to be addressed. We put forth evidence by way of the affidavit of our clients about the potential ramifications of not just the receivership, but our inability to supersede the bond while appealing this to the Fifth Court of Appeals. Based on that, we have requested that the counter supersedeas bond, subject to our rights on appeal, and that we don't believe one is appropriate, but needs to be over $1 million, because that is the EBITDA that the company anticipates having that for the year ending December 2021, which is what this receivership order would impact. And all the evidence we've put in, including the fact that the receivership does jeopardize and potentially puts the company in default on multiple loans, not only to Southfield, which, just to give some context, Your Honor, even if Ms. Pettit's client were correct and won every single thing that they've asked for, they've asked for a repayment of an alleged $500,000 loan, which is not in writing. Not even putting aside for the moment the amount of money we claim on our counterclaims against her client. You're talking about someone who's a potential judgment creditor of $500,000, putting a company into receiver, who has $10 million in loans to other lenders who are saying, do not do this to this company. That's why we think that at least $1 million.
Do we have any affidavits from any of the lenders, the $10 million in lenders, saying that they will put the loans into default if this a receivership is appointed?
We do not, because from the lender's perspective, as I explained at the last hearing, our conversations both by the clients and between the lawyers has been that they are going to wait and see how the receivership affects the collateral of the loan before making a determination as to whether or not to place the company in default.
Would the $1,000 receivership, I'm sorry, did I interrupt? Somebody else sounded like they were talking.
No, Your Honor.
Okay, there was the $10,000 bond that's already been posted. Would that be offset against the total bond, or would there need to be two different bonds?
I think two different bonds.
Your Honor, the amount, of course, of the bond is within your discretion. So to the extent that we can offset that $10,000 bond with perhaps the $21,000 budget for Mr. Buchanan, I think that would make a lot of sense. Essentially, the second bond would just be about the difference between the 10,000 and the 21, so roughly 11,000.
Okay, unless there's some authority to the contrary, that's what I think I want to do, is go ahead and do an additional $11,000. So 10,000. If you can offset the 10,000, then I want to do an $11,000 bond. If I can't offset the 10,000, or if we can't offset the 10,000, then that would be a $21,000 bond. So, anything else today, guys?
No, Your Honor.
Nothing further from us, Your Honor.
Okay, Judge,
All right, guys.
I'm a little confused. Did we reset the hearing?
Oh, did we reset? Good point. Did we reset the hearing?
I'm not sure there's a point, Your Honor, if you've granted the counter supersedious, because I think at this point, the defendants will be filing their emergency motion for stay in the Court of Appeals, and I'm not sure that there's another matter for Your Honor to determine.
Mr. Pettit.
I don't know that we would need a follow-up hearing based on the court's ruling on the bond amount. I guess as a practical matter, I would just request that Ms. Chigueras and Ms. Lopez still move forward with what we had discussed regarding the base numbers, because I do think that will be helpful later on for both Mr. Buchanan and for the plaintiffs.
That was my concern, Judge, is that based on either agreements or the court's earlier rulings, the parties were working together on the production of documents, and I would hate to just see that stop, as opposed to finding some logical endpoint as amongst the parties. I just don't want that work wasted.
Well, I don't think I've suggested that we're going to stop. We have an obligation to continue to produce documents, and then we intend to do that. We will be filing a motion in the Court of Appeals to stay, which is not a surprise to anyone. But I don't think that is a mutually exclusive option.
Let's do this. Let's reset this hearing for 2 weeks. So we'll reset it to put the right year, December 14th at 4 o'clock. And if in the interim, the Court of Appeals stays this, then we won't have the hearing.
Thank you, Your Honor.
And Your
Anything
Honor,
else, guys?
before we sign off, can we submit an order reflecting the counter supersedeas bond?
Yeah, go ahead and email that to Rhonda and e-file it.
Thank you.
Thank you, Your Honor.
Thank you, guys. Have a good day.
Have a good day, Your Honor.
Okay, I think we're here on a minor prove up. Is that right?
Yes, Your Honor.
Okay. I
Yes.
just want to let you know there is a chance that I'm going to be kicked off my computer in about 7 minutes and 30 seconds. So if I disappear, I'm trying to shut it down. I'm having some issues with the software on my county computer. And so if I disappear, if you guys could just stop and let me get back on. All right, so let's go on the record on cause number DC 185533, Ashley Bell versus 10 Sports Bar and Grill, Inc. Counsel, make your appearances.
This is Todd Hunter on behalf of the Bell plaintiffs. If Ashley and Angela could show themselves on the screen.
Hello.
Hello.
Your Honor, Carter Bowers on behalf of defendant 10 Sports Bar and Grill, Inc.
Gordon Trong on behalf of Gordon Trong on behalf of Twin Restaurant Odessa LLC and Twin Restaurant Odessa Beverage Holding LLC.
Ellis.
Al Ellis, the court-appointed guardian ad litem for the minors, Ranson and Baker Bell and Trenton Kelly.
Has anyone submitted a proposed settlement breakdown on this? I don't think I've seen it.
You know what, Your Honor, I have not submitted a proposed settlement breakdown, but my office did submit the projections for the annuities. And I will tell you this, that each minor, the initial settlement or the cost for each annuity will be $22,500. My office is not taking any fees or expenses.
Okay.
The annuities were submitted for Ranson Pierce Bell as well as Baker Reed Bell. The projections for their payout were submitted to the court. Baker's would ultimately pay guaranteed benefits of $31,148.08, as Ranson's Bells would pay $28,284.64 of guaranteed benefits. Now, one issue that has been discussed, Your Honor, regarding Trenton Bell, who is the oldest of the three minors, is whether or not to have his money deposited in the registry of the court, which I would say is the typical mode or typical method of handling his funds, but he will be turning 18 in April of 2021. So there has been mention, I've never done this before, but there was mention of having his money be paid to my office and possibly holding it in the trust account until his birthday, his 18th birthday, and then distributing it so he wouldn't have to go through the court registry. That would be something that Al and I briefly mentioned via email this morning, and somebody had suggested me prior. So that is one discussion, and it would be $22,500 for Trenton.
Okay.
Yeah, and Judge, this is Al Ellis, and I agree with that. By the time you put the money into the registry, pay what it takes for them to deposit it, they can't do a CD. And so then they're going to charge them to take it out of the registry in April. And so at the very least, you might as well leave it in the trust account, plaintiff lawyer's trust account until he turns 18, and then turn the money over to him. So I think that's a fair and equitable and a good way to do it in this particular situation.
What is the total settlement for this entire case?
For all defendants, total is $100,000. It will be $50,000 per defendant group. So Twin Peaks is paying $50,000, and 10 Sports Bars paying $50,000. Now, 10 Sports Bar is not paying a lump sum. They are paying over time. There's just quite a bit more complicated on payments. I don't have it all memorized, but they're doing one lump sum of 20. So that 20,000 will go to Trenton Kelly.
And then, so there's about 66,000 being paid to the minors, and then is the rest of it attorney's fees, or where does the rest of the money go?
The rest of the money will go to Ashley Bell, Russell Bell, and Travis's mother. So, and I'm trying to find that breakdown. I will get that real quick, Your Honor. So Edna, who is Travis's mother, would receive $5,000 out of the total. Russell who was Travis's father, would receive $5,000, and Ashley would receive $22,500, who was his wife, and she's here today. That she's the mother of two of the minors.
So, Judge, from the initial cash payments from the two defendants, it's $22,500 for each minor, and then again for the minor that's about to be an adult, his $22,000, subject to court approval, would go into the plaintiff's lawyer's IOLTA trust account, and then the other $22,500 each are being used to purchase the annuities. And Todd, did you get the affidavit from the annuity person e-filed today?
Yes. Well, looks like it might not have been attached to the filing, and I don't know why. Yes, here it is. Yes. It is page 6 of our filing from this morning. Affidavit of Robin Lynn Young.
I haven't gotten any of that. So can you email the court coordinator that, just so that so we can get it? I guess one of my questions is, I'm about to be signed off my computer. Hopefully I'll be right back. You guys can talk amongst yourself on this. I guess one of the defendants is paying out over time. Who is getting the deferred payments, and who's getting the original payments?
The Ashley Bell, the wife of Travis Bell, would get the ones that are paid over time from 10 Sports Bar. Same with Edna, the mother of the deceased, and Russell, the father of the deceased. The minor settlements will all be paid out of the lump sums approved by this court to either fund an annuity or go to the trust account. And if the court could possibly, the coordinator could possibly send me a chat with the email address, unless somebody else has it handy. Oh, it says I'm now the host. Somebody possibly have the coordinator's email?
Yeah, so hold on a second.
It's rhonda.pinson@dallascourts.org.
Thank you, Gordon.
Mhm.
Dallas Courts or Dallas County?
Dallas
County. Sorry. Dallas County.
I have sent that.
Hello.
Yes.
Hoffman says he'll be on in a second. His computer is updating.
Okay.
Thank you.
Rhonda says she received it, so that's good.
Should be on.
Okay, guys.
Hi.
Can you hear me?
Yes, see you, Your Honor. I did email it to Rhonda. She says she received it. I think she's forwarding it to you, but I don't know if you're able to
Let's
access
go
it.
ahead and just move forward with the approve of.
Okay.
Call
We'll
your
go ahead
first
and
witness.
start with Angela.
Hello.
Please raise your
And
right hand.
Ashley, you probably swear in too, Ashley. You might need to unmute yourself for the swear in.
Do you swear or affirm the testimony? You guys need to raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
I can't hear you.
Yes.
Okay, go ahead.
Okay. Angela, we're going to start with you. Please state your full name for the record.
Angela Renee Anderson,
Okay. And what is your date of birth?
April 18th, 1986.
Okay. You understand that we're here today for the lawsuit involving Twin Peaks, 10 Sports Bar, and Harrington Duffing, and that you are here on behalf of Trenton Kelly, who's a minor child, regarding the passing of Travis Bell on December 23rd, 2017, correct?
Yes.
Okay. You are the biological mother of Trenton, correct?
Yes.
Travis Bell was his biological father, correct?
Yes.
What is Trenton Kelly's birthday?
4/21/2003.
You understand that the defendants, Twin Peaks and 10 Sports Bar, have agreed to pay a total of $100,000 in this case, of which Trenton Kelly would receive $22,500. You understand that?
Yes.
Okay. And you understand that those would settle all of the claims made that you have made on behalf of Trenton.
Yes.
You understand that you're here today to ask the court to approve the settlement for Trenton.
Yes.
You understand and acknowledge that this was a complex case.
Yes.
You believe that this settlement is the best interest of Trenton, correct?
Yes.
You understand that entering into this settlement waives the right to a jury trial on behalf of Trenton.
Yes.
You believe it is in the best interest of him to waive that trial and to proceed to a settlement, right?
Yes.
You understand that if it were to go to trial in this matter, a jury could award more money, less money, or even no money at all, right?
Yes.
Have you had an opportunity to meet with me prior to today?
Yes.
Okay, we've been able to discuss, and I've asked you if you had any questions, right?
Right. Yes.
Are you satisfied with the representation you've been provided in this case?
Yes.
You understand that each of the children will receive a total amount of $22,500 out of the $100,000 total, correct?
Yes.
Okay, and you've had the opportunity I guess you understand that Trenton will be turning 18 in April of 2021, right?
Right.
Do you know what his plans are after that?
He'll be going to college in August.
Okay.
And he's working like part-time right now, so be a full-time student.
Has he already been accepted to college?
He's applying right now to 2 different ones.
Okay. You understand that the money that's being awarded in this case is designated only for him, Trenton, that is. You understand that?
Yes.
You understand that the court here today is being asked to either deposit that money into the registry of the court, which would be accessible at the age of 18 years of age for Trenton, or possibly be payable to the Lyles White firm's trust account to be held into that account until he reaches the age of 18. You understand that?
Right. Yes.
You understand that if further issues arise involving this particular incident for this lawsuit, you cannot go back and change your mind and attempt to set the settlement aside.
Yes.
You understand this case is going to be fully resolved after today.
Yes.
Based on what we've just talked about, you still wish to proceed with the settlement and resolve this today once and for all, correct?
Yes.
Pass the witness.
I'll go.
Anyone else have any questions for this witness?
Yes, Angela, I'll just a couple. I don't want to rehash everything. Do you understand that I represent defendant 10 Sports Bar and Grill, 10 Sports Bar and Grill Inc. in this case?
Yes.
Okay. And do you understand that 10 Sports Bar denies liability in this suit and has proposed the settlement as a full and final compromise settlement release by plaintiffs of the claims, any possibly related claims regarding the events which led to this lawsuit?
I understand.
Okay. And you understand this is a full and final settlement of all those claims that Trenton may have?
Yes.
Okay. And you're settling on his behalf, even though he's a minor. When he turns 18, he will not have the opportunity to sue 10 Sports Bar related to this incident. Do you understand that?
Yes.
Okay. And are you asking the court today to approve the proposed settlement on behalf of Trenton?
Yes.
Are you agreeing to this settlement of your own free will and not based on any representation by my law firm or 10 Sports Bar and Grill?
Yes.
Pass the witness.
Good afternoon, Ms. Anderson. My name is Gordon Trong, and I represent the other defendants in this lawsuit. Just real quick, you've agreed to settle Trenton's claims with the Twin Peak defendants, correct?
Yes.
And you understand that the defendants in this lawsuit did not determine how the settlement proceeds should be broken down?
I understand.
Okay. And no one's coerced you into any settlement as you sit here today, is that correct?
Correct.
Okay. And you understand that no defendants are admitting to any liability in this matter?
I understand, yes.
Pass the witness. Thank you.
Ms. Anderson? Yes, Ms. Anderson, my name is Al Ellis. I was appointed the guardian ad litem in this case for your son, Trenton Kelly. Do you understand that?
Yes.
And because Trenton is close to being 18, you understand there's no way we could do an annuity for him to make a payout. Do you understand that?
Yes.
And then also because he's close to 18, our options are limited, and that is go to the registry of the court, or as we're going to ask the judge, to allow the funds to be placed in your lawyer's trust account until Trenton becomes 18. And are you asking the court to do the latter, the funds placed into your lawyer's trust account until he becomes 18?
Yes.
And you understand that when he becomes 18, those funds, $22,500, is his money. And I know that you're going to counsel him and get him to spend it wisely and that type of thing for college. But the bottom line is it's his money, and he will be able to spend that money as he sees fits. Do you understand that?
I understand that.
All right. I think that's all I've got. Thank you so much. And I'm so sorry. I know it was your ex-husband, but I'm sorry for the loss of Trenton's father.
I know, it's terrible.
Right.
Terrible.
Right.
Mr. Ellis, I'm not sure who would be the most important or most appropriate witness to ask this, but I do want a little better understanding of the liability facts in this. I don't know if that would be better to come through Ms. Bell or Ms. Anderson.
I can give you a very short summary, but I think Todd can do a better job since he's.
I want to hear it from a witness.
Okay.
Which witness?
Do you want me to ask? I can ask them about the occurrence. I think Ashley is probably the most versed in what happened that evening. She is the widow. she was around
Well,
at the time.
let's ask Ms. Bell about that then. So,
Okay.
okay, let's call your next witness.
Yes, Your Honor. At this time, we'd like to call Ashley Bell. If you could go ahead and unmute yourself, Ashley. Can you hear me?
Yep.
Okay, Ashley, can you please state your full name for the record?
My name is Ashley Dawn Bell.
Okay, and what is your date of birth?
September 8th, 1989.
You understand that we're here today regarding the death of Travis Bell, which occurred on December 23rd of 2017, correct?
Yes.
You understand that we're here for the lawsuit involving the defendants Twin Peaks, 10 Sports, and Harrington Duffy?
Yeah.
Okay. At that time, what was your relationship to Mr. Travis Bell?
He's my husband.
Okay. And he was the father of 2 of your children, correct?
Yes.
Okay. What are their full names?
Ransom Pierce Bell and Baker Reed Bell.
Need a moment?
Yeah, I don't know why I'm upset. I don't understand why I'm crying. I'm good.
Okay. Totally fine. But if you want to grab a tissue, you're more than welcome to.
Okay. I don't have one close. I'm okay.
Okay. All right.
Okay.
What is Ransom's date of birth?
August 10th, 2014.
And Baker's date of birth?
April 30th, 2016.
And you are the biological mother, correct?
Yes.
So for December 23rd of 2017, it's your understanding that Travis Bell was in a car accident. Is that correct?
Yes.
Okay. Who was he in a car accident with?
With Harrington Duffy.
Okay. And what is your understanding of who was driving?
Harrington Duffy was driving.
Okay. And were there any other vehicles in this crash, or was it a single vehicle?
It was a single vehicle crash.
Okay. And whose vehicle were they driving?
Harrington's.
Okay. From your understanding, was there any insurance available from Harrington Duffy?
Not to my understanding, no.
Okay. Did you or Travis have any insurance, automobile insurance at the time that would have possibly provided UIM coverage or underinsured motorist coverage?
No. No.
What establishments do you understand Travis Bell and Harrington Duffy were visiting prior to that motor vehicle crash?
Twin Peaks and 10 Sports Bar.
Okay. The very last bar that they were at, which one was that before the car crash?
10 Sports Bar.
Now, prior to the visits to those establishments, when was the last time you saw Travis?
Right before he left to go to the establishments. So
Okay.
it was like, I don't know, like 7 or 8 o'clock.
You understand that the defendants are all denying liability in this case, right?
Right.
And that you, and on behalf of your children, you'll be entering into a settlement where you acknowledge that they're going to deny liability, but they're willing to reach a settlement in this matter.
Right.
Your Honor, before I get into move on forward to the other questions, would you like to hear other questions about the occurrence?
No, I guess not. That's okay.
Okay. You understand that the defendants, Twin Peaks and 10 Sports, have agreed to pay a total of $100,000, which would be $50,000 as a lump sum from the Twin Peaks defendants and $50,000 from 10 Sports, but which could be paid over time, but with a $20,000 lump sum.
Yes.
Okay. You understand that we're here in the court asking the judge to approve a settlement for Baker and Ranson.
Yes.
You understand that, or you have met with Robin Young or her office about selecting annuities on behalf of your two children, correct?
Yes.
You understand that the cost of those annuities would each be $22,500.
Yes.
Okay. I'm not going to get over all the exact payment structure for it, but for Baker, you understand the guaranteed benefits are supposed to be $31,148.08 over time.
Yes.
You understand that the guaranteed benefit for Ranson is supposed to be $28,284.64 over time.
Yes.
You understand and acknowledge that this was a complex case with limited funds with limited insurance.
Yes.
Okay. You understand that some of the parties actually didn't have any insurance coverage at all.
Yes.
You believe it is in the best interest of your children to waive their right to trial in this matter and proceed to settlement.
Yes.
You understand if they were to go to trial in this matter, a jury could award more, less, or even no money at all, correct?
Yes.
You've had an opportunity to meet with me and discuss this matter and prepare for this hearing before right now, correct?
Yes.
Okay. I asked you if you had any questions. You didn't have any follow-up questions, right?
Right.
Okay. Are you satisfied with the representation you've been provided in this case?
Yes.
You've been advised that the children's portion of the settlement will be placed into those annuities and that the children will not be able to receive or get access to them until those point in times that you've agreed to or instructed Robin Young to have them paid out.
Right.
You understand that if further issues arise involving this particular incident, you cannot go back and change your mind and attempt to settle this or to set this settlement aside.
Right.
You understand that this will fully resolve any and all claims that your children have against the defendants.
Yes.
You understand you can't go back at a later time and get more money from those defendants.
Yes.
You agree that you haven't been coerced or forced into taking this settlement, correct?
Yes.
Based on what I've just asked, you still wish to proceed with asking the court to approve the settlement and resolve this case once and for all.
Yes.
Pass the witness.
Defense counsel?
Ashley, you understand that I represent 10 Sports Bar and Grill, Inc. in this case?
Yes.
And you understand that 10 Sports Bar denies liability in this lawsuit?
Yes.
And this proposed settlement agreement, it would be a full and final compromise settlement and release by plaintiffs of their claims and any possibly related claims related to this incident that led to this lawsuit. Do you understand that?
Yes.
Okay. And that includes claims that Ranson or Baker have or could have when they turn 18. Do you understand that?
Yes.
Okay. And you understand as long as 10 Sports Bar and Grill meets its obligations under the terms of the payout in the settlement agreement that has been agreed to, that's all the money that plaintiffs, including your children, will receive from 10 Sports Bar.
Yes.
And do you believe acceptance of the settlement is in the best interest of your children?
Yes.
And are you making the settlement of your own free will and not based on some separate coercion or representation by my law firm or 10 Sports Bar and Grill?
Yes.
Pass the witness.
Good afternoon, Ms. Bell. Do you understand that I represent the Twin Peaks defendants?
Yes.
And you understand that the defendants did not determine how the settlement proceeds should be broken down?
Yes.
Ask the witness. Thank you.
Ms. Bell, my name is Al Ellis. I'm the court-appointed guardian ad litem for your two minor children, Ranson and Baker Bell. Do you understand that?
Yes.
Do you have any questions whatsoever about the proposed annuities for each of your minor children, the manner in which the funds are going to be distributed once the annuities are purchased, what period of time they're going to be distributed, how much they'll be getting after they reach the age 18? Do you have any questions at all?
No, I don't.
All right. One of the things I don't think we may have covered before, but with these annuities, you understand that the guarantee, which your lawyer talked about, the 28,000 plus for Ransom, the 31,000 plus for Baker Bell, that they're guaranteed those total amounts of money on a payout basis through the annuity. You understand that?
Yes.
And I'm sure you've seen on late night TV, the commercials. It's your money. You can do what you want to with it. Let us buy these annuities. And under Texas, I want you to understand that, in fact, annuities can be sold. But all of us here on this Zoom, I think would discourage that because you can only sell them for pennies on the dollar. Do you understand that?
Yes.
But if for any reason you or the kids decide you want to try to sell the annuities, you must come back to this court, this judge, or whoever's sitting in this court at the time, and get permission from the court for that sale. So do you understand that?
Yes.
All right. Again, any questions at all about the annuities?
No.
How are the two kids doing right now, just from the loss of their dad? Are they doing better? Are they getting along, making some progress? How would you describe it?
Yeah, they're doing a lot better. It was harder in the beginning, but they're doing a lot better.
Okay. How about yourself? How are you doing?
Um, I'm doing better. I have hard days, but I'm doing a lot better.
All right. And you understand that there is no amount of money available to pay for the loss that you and those children have experienced. You understand that?
Yes.
And this is simply a compromise of a very hotly disputed dram shop, what we call lawyers call dram shop claim. And based on all the things you've seen and your advice of counsel, under these circumstances, you feel like it's in the best interest of yourself and your children, correct?
Yes.
All right. And again, as the guardian ad litem, I'm so sorry for your loss. I'm sorry for the loss that your children suffered in the loss of their dad. And I just hope as time goes by, all of you will be a little bit better each single day. Okay?
Okay, thank
All
you.
right. Thank you.
Let me ask this, Ms. Anderson, Ms. Bell, do you have any questions for me?
I don't.
Ms. Bell?
I do not.
Okay. Mr. Ellis, do you have a recommendation?
Yes, sir. Just briefly, because I know it's late, this is a dram shop case, very contested liability, lawsuit against one bar that the folks were at the first part of the evening, and then the second bar where they're at the second part of the evening. The second bar they were at did not have insurance. The first bar did have some insurance. They're paying a $50,000 part of the lump sum payments that are being made, as shown by the testimony. Certainly not something that anybody's receiving fair compensation, but based on all the facts and circumstances, it's probably the best thing for all of the minors and the mom and the parents of the deceased is concerned, but primarily for the minors. I think it's in their best interest, and I recommend the approval. Just so the court understands, the division of proceeds, there's $100,000, 22.5% goes to Mrs. Bell, 22.5% goes to each of the three minors, and that's what we've been talking about in the hearing. And then that leaves 5% each for the parents of the deceased. And the adult and the parents, the adult mom and the parents of the deceased will be getting their money through the payout process. The minors are getting all their money in the two lump sums, one being paid by Twin Peaks, one being paid by 10 Sports. And so based on the distribution, based on the annuities, I think it's in the best interest of the miners to settle the claim. I would ask, I know it's a little bit unusual, but I would ask that the funds for Trenton, who's going to be 18, excuse me, in 2021, that those funds can be put into the lawyer's trust account and he can just keep them until Trenton comes 18, and then the funds can be turned over to Trenton. The defendant and I, the defendants for the Twin Peaks restaurant are paying the ad litem fee, and we have an agreement to pay $2,000, and that's in the judgment that's been presented to the court. So unless the court has questions of me, I don't have anything else.
Is that agreed to by defense counsel? The guardian litem fees?
Yes.
Yes, Your Honor.
Is that, you each paid 1,000, or how's that working?
I think the Twin Peaks is paying the whole 2,000, as I understand it.
Yes, Your Honor.
Okay. All right, the court will, first off, I wanted to say to Ms. Anderson and Ms. Bell how sorry I am for your loss. I know this has been a terrible tragedy, and no one is trying to represent that this is a fair settlement for what you've lost, but given the situation, it's probably the best that can be done. The court will approve the settlement as requested by the guardian ad litem, and we'll sign the order. Is that what you just emailed me, was the order?
I did not. I've actually not submitted a judgment, Your Honor, because we were waiting on the ruling about whether or not we deposited in the trust account or the registry. Otherwise, it's
the trust account is fine. Given the testimony, the trust account is fine. So go ahead and email me the order prior to Friday. I'll try to sign it on Friday.
I will get it on file tomorrow morning.
Okay, great. All right, well, you guys be safe out there. The court will approve the settlement and the guardian ad litem fees as agreed to. And anyway, you guys be safe, okay?
Thank you, Judge.
Your Honor.
Thank you, Your Honor.
Thank you.